This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about the KISS rule of law. Keep it simple, stupid. And why a breach of contract is not a tort. And it doesn't pay when suing an insurance company to overcharge a suit against the insurer. In Kole, Westwood, and Keeley, Westwood versus the Travelers Home and Marine Insurance Company and Aaron Harrigfeld, the United States District Court for the District of Utah on June 30, 2025, concluded that the case brought against the engineer, Mr. Harrigfeld, failed completely, and the case against Travelers was limited to the claim that the insurance contract was breached. Plaintiff Kole and Keeley Westwood are homeowners in Utah whose home was damaged in a severe winter storm. The roof buckled under the weight of snow and ice, causing water damage to the house. Their insurer, Travelers, denied their claim based on an engineering inspection report prepared by Defendant Aaron Harrigfeld. The Westwoods alleged that the report contained false representations about the history and condition of their roof. The Westwoods filed a lawsuit seeking judgment for the amount needed to restore their house to its pre-storm condition, along with various claims of damage. Their complaint included 2 contract claims and 3 tort claims: negligent misrepresentation, conspiracy to commit fraud, and fraud. Mr. Harrigfeld moved to dismiss the 3 tort claims against him, and Travelers moved for judgment on the pleading as to those same 3 claims. The court granted both motions, dismissing the tort claims against Mr. Harrigfeld and Travelers. The court found that no party relied on the misrepresentations in the report, which is a necessary element for claims of negligent misrepresentation and fraud. The court also noted that the dispute was fundamentally about an alleged breach of contract, not tort misrepresentations. All claims against Harrigfeld were dismissed, and Travelers prevailed on the tort claims against it. Only the contract claims against Travelers remained live. Utah courts consider a claim for intentional misrepresentation as essentially a claim of fraud, and as the court saw it, all theories suffer from a fatal defect. No one who received Mr. Harrigfeld's flawed report, not Travelers, not the Westwoods, relied on the misrepresentations in that report. That is, no one took the misrepresentations about pre-existing damage to be true and then suffered harm as a result of taking those misrepresentations as true. To understand this defect, consider the elements of negligent misrepresentation and fraud. Under Utah law, negligent misrepresentation occurs when 1. A party carelessly or negligently makes a false representation expecting the other party to rely and act on it. 2. The other party actually relies on the statement. And 3. The other party suffers a loss as a result of that reliance. In addition, fraud requires a plaintiff to show 1. That a representation was made, 2. Concerning a presently existing material fact, 3. Which was false, and 4. Which the representor either A. knew it to be false, or B. made it recklessly for the purpose of inducing the other party to act upon it. And 6. That the other party, acting reasonably, and in ignorance of its falsity did in fact rely upon it, and was thereby induced to act to that party's damage. The parties' dispute, the court found, concerns travelers' purported obligation to pay the Westwoods claim, a subject matter already covered by their insurance contract, laying out the conditions under which travelers is and is not obligated to pay a claim. The suit was limited to the claim that travelers breached its contract, and the court, applying the KISS rule, eliminated everything but that breach of contract. In my opinion, whether an insurer owes a claim under an insurance policy is a question of contract, not tort, not fraud, only contract. The Westwoods took a simple contract suit. Was their claim covered or was it not? And tried to expand it into a tort claim, a fraud claim, but simply did not have the facts to support their tort claims. If their loss is covered by the traveler's policy, they will eventually be paid, and if not, their attempt to make it a big tort suit failed, and so did the contract suit. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 5,100 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you are interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.